everyone. I just realized I started early. I still had like a minute and a half left. I thought I had scheduled it for 10 after, not quarter after. So sorry. I won't do anything for the next minute. I don't even know if anyone's starting. I'm not even over on that page yet. A few people there. Okay. All right. 1 second. 1 second. I'll be right back. Okay. Sorry, I needed a bite. Hey, Megan. Yeah, I didn't plan on starting early. I thought I had it scheduled for 10 after. I was like, oh shit, I hurry up and start it. And as soon as I hit like go live, I saw it still counting down for like another minute and a half. It's like, fuck. Oh well. Although that minute and a half, I could have eaten something real quick. So, what's up, everyone? I see there's people in here, but no, not everyone's chatting. Hey, a lawyer. Yeah, I'm going to come out real quick because I wanted to read these. I haven't even read them yet, so I want to see what they say. I figured I'd just do a reading of them real quick, but that's about all I'm going to do because I'm tired. It's already quarter after 11. So I was just on I'm keeping everyone left the channel talking about John Yates. So weird, I was missing the chat box. Yeah, I don't know. Maybe the page just didn't load properly or something. It happens a lot, I think. I don't know. But yeah, I had a great time over on a real channel. I still call him real, I know. But yeah, we're talking about John Yates and a couple other situations going on YouTube pretty much. So drama stuff. That was fun. Oh, hey, Tiffany. I don't think I said hi. Sorry. I'm just gonna give it a few more minutes before I start reading. Do I even have them up here still? I think, no, I don't. It's all right. I can get them. Yes, accept. Oh, I know where they are. There we go. So yeah, I heard that there was a new filing today. I went to the website and pulled up the 7 men lawsuit, and it looked like there are 3 things submitted today. I don't know what they are really. I seen like the 1 or 2 pages that people were sharing into it, and that's all I've seen. But those did look interesting nonetheless. All right, I don't need that many YouTubes open. And I think I'm good. I don't need that many Twitters. Okay. I don't need that many Twitters. I like saying it like that. So I also just published a new video, or a short video. I don't know if you guys have seen. I published 2 earlier that were addressing a couple of things that UniRock had said, and this one I just posted now addresses something nonsense that had said. I kind of like doing the short clips like this. It's a pain in the ass, kind of just uploading and all the information in there, but like I see myself doing more of those, even if they're only a couple minutes long, as opposed to a couple seconds, because like it just seems to take so long to do like a 20-minute video, especially like if I'm using clips and everything. So I think this might be a good solution for the time being. We'll see. We will see. Oh, okay. I see what you're saying. All right, so I'm going to go ahead and get started. I think. Wow. No, it didn't. I'm starting looking over my comments. And someone from the nonsense page I've been going back and forth with, they're fucking blatantly wrong. So that'll be fun. I get to prove them wrong again. So 3 filings tonight, tonight, whatever, today. From, it looks like we had the second affidavit of Amber Stavig. And that is 7M attorney, I believe. Then we have reply memorandum supporting motion to compel. I think the motion to compel wasn't, I think Katie Joyce side that filed that one, that motion. And then we have reply memorandum in support of plaintiff's motions scheduled for November 21st. So we'll start with the shortest one, which is the reply memorandum supporting motion to compel. Let me pull it up. Come on. And yep, it's the right one. Okay. So here we have 7M plaintiffs, Catherine, defendants, reply memorandum supporting motion to compel. Introduction. Once again, plaintiffs make careless errors of fact and law while seeking the most draconian of measures against an excusable error by counsel for defendant. Once again, how many fucking errors has counsel for defendant made throughout the course of this lawsuit for this lawyer to say once again? I don't know. Here, plaintiffs have 1, filed an untimely response to defendant's motion to compel. 2, made absolutely no substantive arguments explaining why they should not be required to respond to timely served discovery. And 3, misrepresented the record with respect to counsel's communications regarding discovery. Argument 1. Plaintiff's response to defendant's motion to compel is untimely and should be stricken. All right, so like if you, I don't know, I read that and I think if you're pitching that their response is late, well, how late? When do you think you're going to get it if you strike it? Like, if you're really concerned about it being late and that is right there in front of you, why would you want to strike it off the record? Oh, I'm sure that I know that there's a good explanation for it or whatever, but just that's how that sentence reads. Okay. Minnesota provides that responses to motions must be served and filed no later than 14 days prior to the hearing. Since the hearing in this matter is scheduled for November 21st, plaintiff's response was due on November 7th. Plaintiff's response was served on November 9th, making it 2 days late. Accordingly, plaintiff's response should be stricken. Right, yeah. 2, plaintiffs have failed to address the substantive basis for plaintiff's motion to compel. I'm not even drinking. Why am I talking like I'm drinking? The sole defense plaintiffs have ordered for failure to serve timely discovery responses is that they filed a motion for a protective order. The filing of a motion for a protective order does not magically toll the time for serving responses to discovery. The rules require plaintiffs to make timely responses to discovery and identify which requests were Okay, so how long was I missing for? Because I just noticed that that on screen. Let's see here. So how long was I missing for? Because I just noticed that Okay, so I made it to the argument. Okay, so looks like the last page of the filing I didn't get it. I didn't go through. Sorry about that. I didn't even know that I lost internet. I don't know what the hell happened. It's just like the third time I fucking lost internet tonight. I don't know what's going on. Okay, now there I am. Now I'm back on. Thank you, Smear Cat. Hey, Peaches. Hey, Smear Cat. Hey, Megan. Hey, Lily. Hey, Jujubee. Hi, Flying Mom. Tiffany. Hey, Kara. Wait, what? Oh, I have to make this bigger. Actually, do this. It says, I believe that it's only proper to come up with a meter since nonsense always talks and hates Molly. So a meter. Like, does it mean like a friend? I don't know. I'm game though. Come for it. Yay. Okay, so I'm not on that one. All right, I'm going to go ahead and finish reading that last page on the filing because I don't think it came through. And I already took it down. All right. For supporting motion to compel. Yep, okay. That's the one I just read, I believe. Yep, it is. Okay. So it looks like I left off right on here, so I'm going to just pick up on page 3. Through their motion for a protective order on August 26. Moreover, the affidavit of Graham Martin is a detailed recitation of the communication and negotiations that led to the instant motions. The relevant facts are as follows. 1. The deadline for discovery was August 5th. 2. Defendant served timely discovery on August 5th. 3. Plaintiffs did not serve discovery on defendants. 4. Plaintiffs, without complying with whatever, served and filed their motion for a protective order on August 26th. 5. On September 1st, plaintiffs then advised defendants that they would not be responding to any discovery until after their motion for a protective order was resolved. These facts, as well as a detailed recitation of the negotiation around issues related to discovery, a proposed protective order, and the need for an answer, capital A, are fully set forth in Mr. Martin's affidavit. Moreover, or however, the above timeline shows that the motion for a protective order, motion for default judgment, motion for a temporary injunction, and motions for an amended scheduling order were simply window dressing the fact that plaintiffs missed their deadline to serve discovery. The timeline also shows how plaintiffs do not intend to engage in the process. They're simply using this lawsuit as a means to bully Ms. Paulson into foregoing her First Amendment right to report and comment upon plaintiffs. Because that's why the amendment exists. So we can all talk shit about each other. And maybe it does. I don't know. Conclusion. For the reasons stated above, plaintiff's response to defendant's motion to compel must be stricken as untimely, and defendant's motion to compel must be granted. Signed, Martin. Okay, so there's that one. Next we have this one is 8 pages, and it's the reply memorandum in support of plaintiff's motions scheduled for November 21st. Introduction. Defendants in this case have both failed to serve a timely answer in the lawsuit and support its rationale for failure to serve a timely answer. Although it is plaintiff's contention that defendants are in default and do not have a reasonable defense to this lawsuit, should the court allow this lawsuit to continue, plaintiffs respectfully request their previous discovery motions be granted. I'm going to have to put my glasses on. This just isn't working out too well for me. Okay, so default judgment. Defendants have failed to provide reason for their failure to timely answer this lawsuit, capital A. Defendants first claim they have a reasonable defense on the merits of the case. Defendants' support for their reasonable defense is that plaintiffs have refused to engage in discovery. Defendants have failed to provide case law which supports its contention that a plaintiff's failure to provide discovery can defeat a motion for default judgment based on defendants' failure to timely answer a lawsuit. Defendants go on to state that independent media organizations have verified that Ms. Paulson's allegations are true. Defendants' conclusory allegation does not support a reasonable defense on the merits of this case. Defendants have failed to provide facts or law which support their contention that they have a reasonable defense to this lawsuit on the merits. Next, defendants claim they have a reasonable excuse for not answering the lawsuit timely. Defendants' reasonable excuses are: 1, they don't know the Minnesota rules of civil procedure. It's funny. Oh God, it's funny. 2, due to Attorney Martin's family emergency, the answer signed by Ms. Hendrick was not filed. And 3, oh God, the shade. And 3, plaintiffs did not give them a heads up that they would be filing a motion for default judgment a month after the answer deadline had passed. Is it just me, or is this shit as funny as I think it is? I'm laughing my ass off. Well, on the inside, but it's so funny. All right. With respect to the answer deadline, plaintiffs outlined the Minnesota rules of civil procedure and when an answer is due following a motion to dismiss in its memorandum of law in support of default judgment. Further, plaintiffs sent numerous emails to defendants allowing them an extended answer deadline. Several of these emails were sent after the deadline to answer deadline had already passed. As counsel was given multiple opportunities to stipulate to an extended answer deadline and remained engaged via email with plaintiffs regarding this lawsuit, it is not reasonable that the answer was not served on plaintiffs until this motion for default judgment was filed. Regarding defendant's allegations that he was unexpectedly called out of the office and that is why the answer was not filed, the attached emails and the signed answer, capital A, supports a different narrative. Attorney Kristen Hendrick supposedly e-signed the answer on September 2nd. Is this supposed to be capital A all throughout? Because I don't recall it ever being capitalized. Signed the answer on September 2nd, not Attorney Martin. Further, from September 2nd through the 9th, Mr. Martin and Attorney Stavig exchanged several emails regarding discovery. Pursuant to the correspondence exchange and the signing of the answer, it does not seem likely that defendant's failure to answer this lawsuit is due to the unfortunate family emergency of Mr. Martin. Plaintiffs have and continue to suffer prejudice as a result of this late answer. Each day that goes by results in damage to plaintiffs and their reputations. Oh, each day that goes by results in damage to plaintiffs and their reputations. Defendants continue to post about plaintiffs as well as this lawsuit. Plaintiffs have acted in good faith throughout this lawsuit to attempt to stop defendants from destroying their business, their reputations, their personal relationships, and defendants have failed to properly answer the lawsuit. As defendants' time to answer this lawsuit has passed and they have not shown a reasonable excuse for this failure or a reasonable defense to the lawsuit on its merits, the court must grant plaintiffs' motion for default judgment against defendants. In the alternative, plaintiffs filed 3 discovery-related motions prior to defendants' failure to answer this lawsuit. If the court finds default improper at this time, the following are plaintiffs' reply memoranda in support of its discovery motions. Temporary injunction. Defendants have failed to support their arguments. The Delberg factors do not weigh in support of injunctive relief. First, defendants argue that the First Amendment completely prohibits any injunctive relief involving free speech. The protections of the First Amendment are not limitless. Certain types of speech have traditionally been excluded from the First Amendment. There are several delineated exceptions to First Amendment protections, such as obscene speech, fraud, speech integral to criminal conduct, and defamation. These categories are well-defined and narrowly limited classes of speech. Okay. Next, defendants analyzed the Delberg factors and failed to support their contention that plaintiffs are not entitled to injunctive relief. A temporary injunction may be granted if by affidavit, deposition testimony, or oral testimony in court, it appears that sufficient grounds exist. All right, I don't care about all that. Interesting. The balancing of harms favors the plaintiffs. The second factor, okay, I need to turn this light up, and I don't like how it makes my face look, so I'm going to turn my camera off for a moment. Then I can read easier. Oh my God, that's so much better. Holy shit. The second factor involves balancing the harm to the plaintiffs if the temporary injunction is not granted against the harm of the defendants if the court provides injunctive relief. Contrary to the contention of defendants, the harm to plaintiffs if injunctive relief is denied would greatly outweigh any of the harm to the defendants. As outlined in plaintiffs' memorandum of law and supporting affidavits, they have already lost millions of dollars due to defendants' smear campaign against them. Defendants have failed to address the irreparable harm already caused by them at the expense of plaintiffs and instead focus their argument on how it is a harm to them if they are no longer allowed to monetize the false and defamatory statements they have been making. As defendants have provided no case law to support this contention that free speech allows them to continue to publish defamatory information, plaintiffs have properly excused that the balancing of harms is in their favor. The plaintiffs can demonstrate a likelihood of success on the merits. The next Delberg factor requires the court to look at the likelihood that one party or the other will prevail on the merits. If a plaintiff makes even a doubtful showing to likely, okay. Yep, that makes sense. Where did I leave off? If plaintiffs can show that they have a likelihood of prevailing on the merits in merely one of their counts, including defamation, then this factor weighs in favor of granting the temporary injunction. As plaintiffs have shown, they have a likelihood of prevailing on the merits of this case. It is proper for this court to grant temporary injunction against defendants. 3. public policy supports the plaintiff's motion. That's a lot of P's. The fourth factor is whether or not public policy supports the motion. In this case, public policy favors enjoining defendants' attacks against the plaintiff's reputation and business prospects. Defendants fail to address how public policy does not support this request for injunctive relief. 4, the administrative burden on the court supports the plaintiff's motion. The final factor involves looking at the burden on courts in the supervision and enforcement of the injunctive relief. Defendants urge that plaintiffs' lengthy list will be impossible for the court to monitor because it is so burdensome and confusing. The example they wish to use is that there's a difference between publishing comments or publishing statements that plaintiffs have been accused of human trafficking violations or that plaintiffs have engaged in human trafficking. The underlying basis of this lawsuit is that defendants have made false and defamatory statements about plaintiffs, including that there have been credible accusations of human trafficking. Due to the egregious nature of plaintiff's statements and her own alleged inability to recognize how accusing someone of human trafficking could possibly make her liable for defamation, it is even more clear that a temporary injunction should be placed against defendants as outlined in plaintiff's memorandum of law. Protective discovery order. Defendants, in their memorandum of law opposing plaintiff's motion for a protective discovery order, have failed to show a legally cognizable reason plaintiff's motion should not be granted. In fact, counsel's failure to recognize how their own clients' behaviors and statements are or could be construed as potentially leading to the public dissemination of highly sensitive information supports plaintiff's motion. Defendants argue that plaintiffs have failed to show good cause exists for the assurance of a protective order. This allegation is supported merely by defendants' belief that the old posts, which are the subject of this lawsuit, were proper in the first place. What? Plaintiffs have specifically alleged that defendants had previously disclosed documents which were private, sensitive, and in some cases subject to a protective order. As outlined in plaintiff's memorandum, this dissemination of documents obtained during court proceedings and subsequent misstatements of facts and law about those documents are partially why plaintiffs are requesting a protective discovery order in this matter. Defendants' only defenses are defendants' posts indicate that they are public documents available on PACER, and that defendant's statement, discovery is about to get real. That's funny. Should not be construed to mean that defendants plan to decimate information and documents obtained through the discovery process. These statements are contrary to the facts. Defendants have consistently and mercilessly posted filings from this case, letters between counsel, and have also posted depositions from other cases and misconstrued what the documents state. In addition to defendants' Due to the nature of the lawsuit, confidential information already decimated by defendants' egregious lies about plaintiffs, the irreparable harm already bestowed upon plaintiffs, and defendants' involvement in a discovery about plaintiffs respectfully request that the relief requested in the memorandum of law be granted. Amended scheduling order. Defendants in their memorandum of law opposing plaintiff's motion for an amended scheduling order failed to list a legally cognizable reason plaintiff's motion should not be granted. Let me check that before I keep reading. Make sure I'm not being told I'm not on stream again. Yay, okay, it's not for me. Okay, all set. Where did I leave off? Okay. Defendant's sole argument is because plaintiffs failed to engage defendants on the topic of discovery until the deadline for discovery had passed. As outlined in plaintiff's memorandum of law in support of an amended scheduling order, the scheduling order stated, this order may be amended only at the scheduling conference requested by either party within 10 days of notice of this order. The plaintiffs attempted numerous times to contact the court to obtain a scheduling conference in compliance with the scheduling order for the 10 days following its issuance and through the discovery deadline. I feel like I'm reading like shit tonight. Plaintiffs also contacted defendants to meet and confer regarding a stipulation to an amended scheduling order prior to filing this motion with the court meeting its requirements under, okay, whatever. As plaintiffs have failed in good faith to follow the direction of this court and Minnesota law, it is respectfully requested that a scheduling conference be held to discuss the timing of discovery, motion, deadlines, mediation, and how long the parties will need for trial. Yeah. Absent a scheduling conference and an opportunity to make, okay, I'll make them both. Let's see where that sentence ends so I can just pick up on the next one. All right. What's going on here? Plaintiffs also request that if an order on this motion takes longer than 10 days to be issued by the court, that the above referenced time periods be considered as of the date the order is issued, not the date of the hearing. Conclusion. Yay. Defendants have failed to timely answer this lawsuit, and therefore default judgment should be entered against defendants and in favor of plaintiffs. Alternatively, plaintiffs request their motions for temporary injunctive relief, a protective discovery order, and an amended discovery order be granted. So there's that. And lastly, we have the long one. The fucking long one. Okay. This one was filed, the 14th. Okay, so this is the second affidavit of Amber Stavig. Okay. Being duly sworn to pose in the states. True and correct copy. I'm not going to read all that. Right. So she signs it, and here's what she submits. Looks like emails. This is from Katie's lawyer to 7M's lawyer. Hi, Amber. I have not impugned your character or questioned your professional integrity, and I would appreciate if you do likewise. What? I am under any number of professional obligations not to disgorge information obtained during discovery, and I do not intend to do so in this case or any other. As for your statement about the necessity of our potential motion to compel discovery, you have now issued conflicting statements. Please clarify for me which of these is the correct statement at this time. You will provide discovery upon our stipulation to a protective order only, or you will provide discovery upon our stipulation to a protective order, an injunction, and an extension of the discovery deadline. Mm-hmm. Huh. Sorry, I get distracted by something real quick there. All right. Prior discovery deadline. Your most recent email suggested that your position has changed to statement. Oh, did I read that? Yeah. Statement A, while prior to today, it was statement B. I would like to know what you are requesting or proposing so I can help my clients assess your proposal with clarity. Thank you. All my best, Graham. Now, this is 7M's attorney responding to Katie's attorney. Mr. Martin, right? Yeah. I will not be sending discovery to your office absent a ruling on our motion for a protective order. I do not trust that information sent to your office will remain in your possession, especially given your refusal to stipulate to a simple agreement that your client not post about my clients or share information obtained in discovery with third parties. Given the egregious nature of the allegations your client has made about mine and her involvement with an up-and-coming Netflix documentary about my clients, I think it's more than reasonable that all documents and discovery in this matter be contained. If you would like to discuss a reasonable stipulation regarding the motions I have made, I am willing to discuss. If you feel it necessary to file a motion to compel when I have stated that I will send discovery to you immediately upon a stipulation to protect discovery, that is your decision to make. Thanks, Amber. Then we have Katie's attorney, 27M's attorney. Good afternoon, Amber. I have read all your correspondence, and we understand you and your client's positions on the issues currently before the court. Who's this? Yeah. We are of the opinion that the proper time to either ask us to stipulate to extending the scheduling order deadlines or to make a motion to do so was prior to the deadline expiring. We do not know why your office chose not to come to us directly to discuss extending the deadline. And we do not know why your office chose to seemingly engage in ex parte communications with the court to try to extend the deadline. Whatever the case, the time to handle this by stipulation or by motion was prior to August 5th. Now it is September 8th, and your discovery is overdue. Per the rules, your clients have waived all their objections to our request, and the discovery responses are still owed to us. Did I listen to that? Every time I hear that go out, I think someone's trying to get a hold of me. No, I'm good. Okay. Request and the discovery responses are still owed to us. Oh. Okay. Sorry about that. We understand that your clients think some of the information we requested is potentially sensitive. That information is also directly relevant to the claims your clients have made in their suit. So it is necessary and needs to be disclosed, regardless of the existence of a protective order, that is. If any information needs to be included in any motion to discuss or other court filings, we will absolutely comply with our redaction responsibilities, as well as any other obligations to keep documents confidential under the law and the rules. However, the only way to get out of producing information and documents relevant to the claim and defenses in this lawsuit is for your clients to dismiss the suit. Absent such a dismissal, your clients, that's funny. I just keep thinking about this one store. Absent such a dismissal, your clients are obligated to meet their discovery obligations under the rules. If they had wanted a protective order in place prior to the deadline for producing their responses, any time since serving the summons and complaint would have been a good time to do so. Waiting until the discovery deadline and using the lack of a protective order as a shield for not producing discovery means it. Okay. This is like so boring. Okay, if they wanted a protective order in place prior to the deadline for producing their response, anytime since serving the summons and complaint would have been a good time to do so. Waiting until the discovery deadline, I think I already read that. Okay. Please provide complete responses and documents by the end of the day on Tuesday, September 13th, or we will file a motion to compel discovery. If you are willing to commit in writing to providing your documents by that date, I will entertain a stipulation to a limited protective order for anything that would be considered protective health information under the law. Any stipulation would be only for that purpose, though, and not for any other items your clients continue to demand. See, I read that, and it just sounds to me like Katie wants this information public. And I don't know, I just really feel like she wants this information public because she put the cart before the horse. She wants to make the claim and have her case proven and then worry about the evidence to back it up. That's kind of how it comes out across, I think. Anyway, almost done. Well, kind of almost done. Are these all emails, really? All right, I'm not reading fucking 38 pages of emails. Okay, no, it's not quite that much. All right. All right, so I think this is where I left off. Yeah. Mr. Martin. So this is 7M's attorney addressing Katie's attorney. Our office has been attempting to contact the court almost daily since the scheduling order was sent out. I had my paralegal call the day we filed the motion, as well as again today, to attempt to obtain a hearing date regarding the motion which was filed. Pursuant to the scheduling order, the court was supposed to settle our request via scheduling conference. As Judge Davis has been out on leave, this did not occur. Your frustrations with my office should be directed toward the court. I am just as upset by my inability to obtain a call or email back from the court to schedule anything. I have attached an email from my paralegal with her latest correspondence to the court, their response, and her statement that she did, in fact, call the court again this morning to attempt to schedule a hearing date. Your client has a history of doxing people on the internet. Huh. Okay. Pursuant to the scheduling order, the court was supposed to settle our request via scheduling conferences. Okay, it did not occur. Your frustrations with my office should be directed toward the court. I am just as upset by my inability to obtain a call or email back from the court to schedule anything. I've attached an email from my paralegal with her latest correspondence to the court, their response, her statement that she did in fact call the court again this morning to attempt to schedule a hearing date. Your client has a history of doxing people on the internet, displaying documents obtained during the discovery process on her social media handles, and misconstruing the contents of documents she posts. This entire case is based on your client's egregious behavior. As such, our request that your client not be allowed to post medical records, leases, and sensitive financial information on the internet is appropriate. In your request, you asked for highly sensitive information no reasonable person would want shared with a stranger, let alone the entire internet. As I stated before, we are ready to send you discovery immediately upon stipulation to a protective discovery order, stipulation to a temporary restraining order preventing your client from posting about mine until the conclusion of this trial, and a stipulation the scheduling order be amended given the court's refusal to call us back in time to schedule a discovery conference, which the scheduling which a scheduling order explicitly required. None of these requests are reasonable are unreasonable in this case. If you would like to stipulate to the above, I will retract my motions and we can have discovery to you next week. I will be unavailable until next Tuesday as I'm leaving town for the long weekend. Okay. Katie's attorney to 7M's. Good afternoon, Amber. We are in receipt of your letter e-served yesterday and are surprised to see that your clients intend to deliberately not meet their discovery obligations. There is no stay of discovery in this case, nor is there any imminent decision on your motions, given that you have yet to even schedule those hearings. Your clients have demanded relief outside what is available under the rules, but hasn't even managed to schedule hearings on the motions requesting that relief. There is no relief on the horizon or the sort you have requested, and therefore absolutely no basis for the sort of delay you have stated your clients intend to unilaterally impose. Regardless of whether your clients would prefer to abstain from discovery, and regardless of their positions on the discovery order in this case, under Minnesota rules, the discovery responses are due Tuesday. Based on your letter, we understand that your client intends to miss that deadline deliberately, but without any cognizable legal basis to excuse their failure. Notably, a party's failure to timely respond to interrogatories or make objections waives all objections except those related to privilege, work product, and experts' conclusions. Please confirm that we will receive the discovery responses no later than this coming Tuesday, or we will move to compel. Seek our fees incurred in doing so, argue that your client has waived any objections, and seek any further relief as warranted under the law. Alternatively, should your clients prefer not to engage in discovery in this matter, they can always choose to dismiss their case with prejudice, at which point their discovery obligations will cease. If they choose this course, please inform us of that choice prior to Wednesday, September 7th, so we can forego incurring the expenses of bringing a motion to compel discovery. Thank you again for your attention on this timely matter. Oh, man. So, next we have, I think there's only a couple. I scrolled down. There's not a whole ton of emails left. Let me check chat, though, and give my mouth a break for a moment. I do find it interesting that the court allowed/put on the docket the motions of 7M file. Yeah, I thought I was going to be reading all Katie's shit, but this last one's not Katie's, it looks like. Hey, Autistic Shell. Hi, Steffi. I think she is trying to lure people to use her in a documentary despite her clear reputation. I don't think what she has presented them thus far has impressed them. I kind of agree. And I think that she was really relying on being the catalyst that caused the documentation to be released that supports her claims. Like even if she did not obtain them or they were not handed to her, if they just get out as a result of having had to be produced because of this lawsuit, Katie can run around and claim victory. I think that look at what my lawsuit made them do. Yay, my lawsuit helped people. So that's what I'm thinking. All right, let's see how through all these. I enjoy how through all these emails, the 7M lawyer never said respond to the lawsuit. Yep. Okay. I don't see anything here in chat. I'm going to go back over. That's funny. Okay, so where am I? Am I not sharing it? Have I been not sharing it this whole time? It's gonna be fucked up. I might have put this one up there. Okay, well, it's up there now. Sorry, I am a little tired. It's been a long day. I didn't sleep much last night. I'm going to pass out as soon as I'm done there. I want to read these though. So, hi, Amber. So this is from Katie's lawyer to 7M's lawyer. My client remains disinterested in the proposed stipulations. We are already working on an answer and will have one filed in the next week or so. I didn't see a directive as to when the court expects it to be filed. So absent such a directive, we will just create and file it with all deliberate speed. Thanks. All my best. Amber says, thanks, Graham. I will discuss settlement with my client and see what they are open to. As stated in my previous email, unless we can stipulate to a protective order, we will be moving for one, and I plan on filing that motion this afternoon. I'm not sure how much your client wants to spend on an answer, but we could be open to an agreement to extend the answer deadline pending settlement if we stipulate to a discovery extension and simultaneously request the court for an amended scheduling order. So there's that. Then Katie's attorney to 7M's attorney. Good morning, Amber. We are in receipt of the order, have reviewed it with our clients, and are considering the impact it has on this case. As to your contention, I understand why you are seeking a stipulation to extend discovery, but I'm not sure that my clients need any depositions in this matter. We have issued our timely discovery request relevant to the issues your clients raised and are awaiting timely responses to those requests. We do not need that deadline extended. If your clients would like to discuss settlement instead at this juncture, I think that would be fruitful. I will discuss your request with my clients and follow up with a final response on the front. Yeah, I think it was the front part. But I think in the meantime, it would be best if we discuss methods of disposing of this case and saving everyone a lot of money. Okay. Now, Katie's attorney to Graham Crackers. Graham, I'm not sure if you have received the order on your motion to dismiss yet, but I would recommend that we agree on a stipulated discovery plan, extending discovery deadlines, and requesting an extended scheduling order. I anticipate that we will need several depositions in this matter, and I wouldn't want to force everyone to rush to push this through. Yeah, I'd be surprised if this held up, really. I don't know, I don't know. So, all right, we have, wait a minute, okay. Graham to Amber, so Katie to 7M. Good afternoon, Amber. Thanks for getting in touch. A number of times since this case began, you have asserted that we agreed that neither party would talk about the other publicly during the pendency of the case. But I've reviewed our email correspondence, and the only thing we agreed to do was not to disclose online the contact information of the parties or their attorneys. If you have a different written agreement than what I have just described, will you please send a copy of it to me so I can review it and advise my client of it? I don't think such a thing exists, though I am unsure of the continued insistence that my client is violating it. I appreciate the reach. For a second there, I thought I said I appreciate the reach around. What the fuck? Oh my God, I'm getting tired. I appreciate the reach out about the other matters and will discuss them with my clients and get back to you in a timely manner. Thanks again. I hope you are otherwise well. Have a good afternoon. So that's that one. Right. Oh, okay. So this. Oh, I didn't read that one yet. Did I read the one about COVID? You know, that one I just read. Okay. All right. So 7M to Katie Joy, I guess. This email is being sent as an attempt to meet and confer regarding several issues regarding the 7M and without a crystal ball litigation. I have been informed that your client went on another social media spree wherein she spread false information about my clients and their associates last night. On one such post, two of the dancers she talked about in the post explicitly told her the post was false, and her reaction was to taunt them and state the information was her opinion instead of taking down the false information. I've also been informed that your client has a documentary deal with Netflix and that she has been advised to post about my clients in an effort to promote that documentary. Previously, we have discussed via email that neither of our clients would talk about the other on social media. It is clear your client has no intention of refraining from telling lies about my clients. As such, we will not be responding to your discovery requests or issuing our Rule 26 disclosures until either a protective order is issued by the court for the information disclosed by my clients. You have requested highly sensitive information And the basis of this lawsuit is that your client is spreading falsehoods and disclosing confidential information to third parties. If you are interested in agreeing to a stipulation to confidentiality, please let me know by noon this time Tuesday. If not, I will be filing a motion for a protective order with the court and will request that all discovery only be viewed by the attorneys and in hard copy format in my office. Okay. Additionally, I will be requesting the judge order an issue for an injunction against your client posting on social media or discussing this case or my client's affiliates to any third party, including Netflix producers and others she may have contracted with and requested a motion to extend discovery. I attempted to contact the court several times a week from the date the scheduling order was issued until I filed correspondence to get a motion hearing date from the court for a motion to modify the scheduling order, and I never received a response back from the court. Pursuant to the court's correspondence to both of our letters, I will be filing a motion to amend the scheduling order as well. If you would like to stipulate to either of these items and have the judge sign off on them, please let me know by noon this Thursday. Finally, you have not filed your Rule 26 disclosures, and we have not discussed a discovery plan. I think it would be beneficial for both of our clients if we can come to an agreement regarding discovery instead of fighting each issue by filing motions and requesting discovery conferences, and the judge, who I am assuming has a backlogged calendar from COVID. Please let me know if you're open to discussing an amicable agreement to the issues relating to discovery and your client's continued harassment of my clients. Okay, next. I'm going to start skipping some of these, I think. Next, we have from Graham Cracker from Katie to I guess, no, to Amber. I wonder though. Okay. Received. I will communicate with her about those items. Presumably you have had the same conversations with your clients already regarding online information. I note that they have changed their contents of their website very recently to recharacterize what they do. I hope they too are preserving any relevant evidence related to the allegations of the parties. Thanks for the amended complaint. I'll look it over and make sure we get you an answer in a timely fashion. April 26th sound right, given the amendment? Please let me know if you need anything else from me in that time. All right, I'm going to check the chat here real quick. Yeah, I agree, Flying Mom. Graham is very condescending and arrogant. And like Amber just like, I don't know, just throws out the best like snark every now and then. Like when she's like pissed off, she lets it be known, but just in a, I don't know, in a funny way. Like she's comedic. I like it. I truly wonder how this will play out too. What do you think the documentary is really about? I'm going to guess it is in 7M. See, I think it started off being about 7M. I think that was, in fact, maybe the overall intention of it. Like maybe they bought into Katie's claims a little too much. But I think maybe throughout the course of this unfolding, I mean, I imagine if I was one of the people working on the documentary, one of the writers, whatever, the directors, the producer, whatever you want to call them, if I was one of them and I had my sights set on covering like the pseudoscience shit or whatever, and then I came across Katie, like I wouldn't be surprised if the documentary makers are kind of just turning back and looking at her at the moment. I don't know. Oh, okay. Scroll down past the emails. All right. Yeah, I'm going to skip the emails. If you guys want to read them, you can read them. I'm going to skip most of them because I am getting very tired. Oh, looks like they're getting along there. Additionally, I was told she temporarily posted my client's in-house counsel's phone number on her Instagram story yesterday, and she posted something with the name of a realtor selling a house near Mr. Shin's on another post. I would appreciate it if you could relay to your client to abstain from posting information on her page relating to personal contact information of my clients and their affiliates. Who wrote that one? All right. So it was written to Mern. So it was, all right. 7M asking Katie. All right. Let's see here. Okay, here we go. Selling Souls, the Cult of 7M, an active investigation. Exhibit D. What's going on? A group of famous dancers are allegedly being held hostage by a religious cult disguised as a management company. Their pastor, Robert Shin, a career con artist, controls every aspect of their lives, from their finances to their love lives to ultimately the separation from friends and family. Selling Souls will expose the evil behind the influencers. This is a multi-part documentary series that will investigate 7M Films, a talent management company used to recruit influencers into the Shekinah Church by founder and pastor Robert Shin. We will hear from ex-members who have been silenced for decades while we build a case against Robert for past crimes that he's committed and those that he is currently committing. That's fucked up. We will profile the group of influencers who are believed to be under Robert's control and the stories of friends and families who have lost their loved ones to this cult. I understand. I can't really read that. Without proper representation, the dancers feel like the industry was taking advantage. Okay. Well, that's not what I saw. All right, so the Shekinah Church International was born with the calling to save 1 billion souls, raising up leaders for the body of Christ and supporting the gospel with all means. The church is based on the Seven Mountain Mandate, a belief movement with emotion-based faith ideology that originated in 1975 and is followed by 25% of the world's Christians, a staggering growth from 6% in the 1980s. The followers of the Seven Mountain Mandate claim their job is to overtake education, religion, businesses, government, entertainment, family, and the media, sanitizing them all of witchcraft or demons. The Shekinah Church's mission is to save 1 million souls, raise up leaders, share the Father's love, build his sanctuary, and support the gospel with all means. This includes firmly committing their lives to the whatever. Right. The influencers and the evil behind them. Robert Israel Shin, Robert's right hands and senior staff. History of the Shekinah Church, the lawsuit creation of 7M and their targeting of the entertainment industries, interview friends and families. Okay, there we go. Our way in. We open the series in present day. We will see the 7M dancers' content and what seemingly is just another day on social media. That will come to a screeching halt with a cry for help from the Wilking family and VO from ex-members of the church In a VO, we hear he calls himself man of God. He's a con artist. It was his version of solitary confinement. That was the first time I escape in the middle of the night. He's evil, pure evil. We then flash back in the morning, we then flash back to the beginning. Through interviews from ex-members, family, and friends, church footage, files, and recordings, we will learn about the beginning of Shekinah Church, the escalation of evil, and the crimes committed by Robert Shin and his staff. These events from the past will be intertwined with what we're seeing in the present day, from the dancers sharing with viewers the severity of the situation. All right. Yeah, I'm not going through all those. All right, so it's close to the end. What is it? Why won't it get bigger? Come on. We have filed a letter and our answer to Robert Shin's attorney in the court today. The court never gave us a deadline to file. Oh, yeah, we read that. I remember reading that. What are they saying about it, though? Anything? Maybe not. Robert Shin admits to extramarital affair, providing housing to church members. Oh my God, he housed church members. What a fucking scumbag, man. How he fucking housed them. Like, how does he even know that they were without a home? Because he said so. I mean, I don't know. I think it's all a conspiracy. They're all just trying to rip off of the other members' money. So he housed them. Fucking dick. Anyway, it claims some members have been physically abused by other members in an attempt to combat demonic forces. Again, I'm not reading all these. I'm tired. I'm going to wrap this up. Actually, I think that's it. So, if you guys want to download it and read it, by all means, go ahead. Let me turn this down. There we go. I'm going to check out the chat real quick, and I'm going to wrap it up. I still have a different theory on the documentary. Oh, yeah, what is it? Is this the documentary trying to get financial backing? I don't know what documentary that is. I've been under the impression that the documentary being discussed here is one that provided Katie Joy with her team. Wait, I need to read that last paragraph about how it won't be a one-sided story. Okay. Let me see. Where is it? Do you know where it was? Here, I'll share the page. So I'm going to scroll it to words, letters, and shit on the screen, and then I'm going to stop and look and see if you're telling me to stop. Okay, I don't think that's it. Effort to get discovery. I wonder if this is what you're talking about. I went back and found it. Oh, thank you. Okay, you're welcome. Awesome. Awesome. Okay. Look at this quick. Okay. All right, guys. Yeah, I'm going to wrap this up. I'm going to go to bed, maybe eat something. I don't know. But it's 12:30 here, so I'm due. I'm ready for bed. Hey, Jan's insurrection. Jan 6 insurrection. Oh, okay then. That's an interesting name. I'm going to ponder this, but I still have theories. I look forward to hearing those theories. So that is interesting. They are telling KJ's side and Shin's side. That's what I kind of thought was going to happen. Like if they, part of me did kind of think, what if they like just totally flipped the script and just did a documentary about how fucked up she is? But then I thought, no, I really hope that's not the case because she would love that. But yeah, I bet that they're going to like tell both sides of the story and just let Katie hang out there all by herself to dry. I think that might be, you think you might be onto something there. All right, guys. I have to work tomorrow, so I don't think I'll be streaming at all. I'll be around Thursday. So have a good night, everyone. Thanks for being here. I don't know where my exit door is. Bye.